Hello, and welcome to Civility and Solutions, a podcast brought to you by your Court Services section of the Supreme Court of Ohio. I am your host, longtime justice enthusiast, Kate Munger. This is a podcast about inspirational ideas for courts from across our 88 beautiful Ohio counties. The idea of a podcast was conceived as a way to be able to bring content that was developed for the 2020 Dispute Resolution Conference. That conference was unfortunately called off for that plan-crushing pandemic called COVID-19. We are happy to be able to use this platform to share solutions and challenges with courts and any listeners who want to stay on the cutting edge of dispute resolution and court services issues. The views expressed by guests to this podcast don't necessarily express the views of the Supreme Court. Today's topic relates to commercial mediation. Commercial mediation focuses on the rights, relations, and conduct of persons and businesses engaged in trade and sales and seeks to solve problems without litigation. Welcome to Season 1, Episode 2. Our topic today is tailored mediators' proposals in commercial cases. Joining me today, the legal craftsman behind your Columbus Clippers is Frank Ray Esquire. Thank you for being here today.
Well, thank you for having me, Kate.
Look, I've got my Columbus Clippers cup here to show solidarity.
Great. That's fantastic. Thank
you. Well, I did a little poking around and fun fact, found out you were really instrumental in the formation of the Clippers and the building of the stadium. How did you get involved in that?
I just was sitting at my desk as an assistant Franklin County prosecutor, and my boss, George Smith, told me that he had an interesting project. I met with the Franklin County commissioners. This would have been in August 1976, and here we are in 2020, and I'm still doing the legal work for the Columbus Clippers.
That's awesome. That's so fun. Are you like super fan then? Do you follow the team? Yeah, I would. That's so cool.
Yeah, it's been an interesting turn in my legal career, and that I've enjoyed and have had great opportunities that have arisen from that engagement.
Well, Mr. Ray, you started your career in 1973 as assistant prosecutor, and then within several years, 2 years, 3 years, you were the chief civil counsel for the Franklin County Prosecutor's Office. That is meteoric. I mean, I started at the prosecutor's office, but 3 years out of law school, I was still trying to figure out how to transfer calls without dropping them.
For me, it was right place, right time.
That's amazing. And then for 40 years or so, you dabbled as a civil litigator.
I did. We just seemed to show up at the courthouse on a regular basis, and enjoyed that part of my career. And now I'm committed to private mediation and working with the courts on mediation projects, and occasionally doing some assignments that originate from judges' chambers.
What did you enjoy about litigation?
Well, I love the competition, and I enjoyed the personal contact with people. There's nothing more personal than the litigation process, and that seemed to fit with what worked for what I was able to bring to the table as a lawyer.
And you have also been a professor at OSU Moritz. What was that like teaching at your alma mater?
Well, I taught the trial practice course in the evenings, Kate, and I would say that probably everyone who's watching this telecast would agree that if you have the opportunity to teach, you're probably the main beneficiary of the teaching process. I feel it made me much better as a lawyer, and just as preparing for this podcast, I think helps refocus as to why we do things professionally and how we do them to achieve our goals. Arises from being engaged on the front lines of the educational process. So thank you for this opportunity as well.
Oh, I'm pleased to be here. This is very fun for me and educational for me as well. So now you're full-time services as a mediator for complex civil cases. And what skills did you learn as a litigator that help you now as a mediator? Do you think that was beneficial to have that experience?
I hope so. I think that so many of the parties and lawyers appreciate that I can hearken to 4 decades of regularly showing up at the courthouse and actually trying cases so that we can project that experience onto the ranges of results that might occur from one piece of civil litigation. So yes, I think that experience as a trial lawyer has been a major asset in what I'm able to bring to the table as a mediator. I would say that having trial experience is not necessarily going to make a mediator a skilled and helpful facilitator, but it is one ingredient that, particularly for commercial cases, can be helpful.
And so you are all set to present about commercial mediation at the Dispute Resolution Conference in March. Are you ready to try that topic on this new podcast format today?
Let's give it a go.
All right. Now, you talked to me before we recorded this about collision of egos. What does that mean, a collision of egos in a commercial mediation context?
In trying to prepare for the presentation on the topic of complex commercial mediation, it dawned on me that the profiling of those cases starts with the kind of people involved as decision makers. When we're engaged in commercial cases and the mediation of those cases, at the end of the day, the decision maker is almost always a high-ranking individual within the corporate or business or organizational structure. For those kinds of people to have achieved success in the business world, that's probably driven by a strong individual ego that unavoidably will be projected into how decisions are made, with egos sometimes superimposed on that decision-making process. So when we begin to assess how to effectively mediate commercial cases, if the ultimate goal is to achieve resolution, then dealing with the person who's going to give a thumbs up or a thumbs down to that resolution process requires an understanding of the individual egos involved in making those decisions and ensuring that those decision makers are involved. If there is some kind of interposing of, for example, general counsel who doesn't have the decision-making process, who seems to be driving the bus for the business organization, but at the end of the day still has to make the call to the decision maker, the effectiveness of the mediator really has been tainted. So one of the goals that I find that I need to try to achieve from the very outset of my commercial mediation cases is to ensure that I as the mediator and the adversary parties also have access to the real decision makers in the disputed civil matter.
So how do you dig down to what the real heart of the conflict is between the parties?
For the most part, Kate, I rely upon the litigators, the lawyers who are those who've appeared in the case to educate me. And that starts usually with a comprehensive mediation position statement. I confess that many times, because we have access through the common pleas courts and the federal courts to electronically stored filings for cases, I'll go to the public sites and try to make sure that I understand what has happened in a case if I don't feel that the mediation position statements are adequate to inform me about the procedural status of the case, who's really been the active lawyer in the case, who's been filing affidavits and motions for summary judgment on behalf of the corporations. Those things can be very helpful, and it doesn't take very much time. And because of the fantastic jobs that our courts have done in terms of producing electronic public access to court filings, there's ease of access.
Now, some of us in the legal field have done anything we can to avoid both science and math in our careers, but you embrace science. Is that true?
I would say that I embrace the scientific method, and the background of that involves trying to determine how to best go about engaging and securing the confidence of decision makers. When we start with the premise that decision makers who had great success within corporate America, in the business community, and in their personal lives, they have probably done so with application of fundamental logic in order to secure and have those achievements in their lives. So that premise, I have found, has been very helpful to me, because almost universally, as if profiling these cases from the get-go, that has been a nice turnkey for me in starting with the process of how to be influential with decision makers at the end of the day. And although influence shouldn't necessarily be the thrust of how we mediate cases, because we're facilitators, we're neutrals, I'm often finding that in commercial cases, the decision makers are used to turning to experts within their own organization and independent experts to make decisions, sometimes assuming the role of a quasi-consultant with the permission of the decision maker, either expressly or impliedly, is when I begin to use the scientific method. That can only occur once you have actually secured and have demonstrated a rapport where the confidence of the decision maker will be projected into conversation and in the actual decision-making process. So with this thesis of having logic as a basis for how decision makers make their decisions, I use the scientific method.
Okay, so as for mediators, can you walk us through how a mediator would use the scientific method?
Yes, I come from a family of scientists. You would never know that looking at my grades and science topics.
Well, your dad was a professor of agronomy at Ohio State University, so you have teacher shoes to fill here, science teacher shoes. So
to a degree, I didn't really have, my brain didn't work like his, but I will say this, the scientific method is readily understandable and employable. So let's just go through the steps of what I would invite those who mediate to apply in making determinations on how a mediation is going to be directed and therefore facilitated effectively. The most important thing that I think we need to start out with in the scientific method is the observation stage. And so you can look, you can see, but there's a difference. Observing is the better word for the first step in the scientific method, because it's a collection of information. Sometimes it seems so disparate, but actually getting information on a person's background can give you insights as to how he or she has an orientation in making decisions. So I call it my voir dire stage. Just going back to my trial days where jury selection I found was so important in the trial process. I do a voir dire of the lawyers, the people who've appeared on behalf of the businesses, and I take quite a bit of time with it, actually, to really understand. And also, it's an opportunity to find whether or not there's some overlap of experiences that you can use to help people identify with you. So using that kind of information and having conversations that are just flat out personal as they unwind, I found has been extremely helpful to establishing rapport and at the same time gathering information to assess. And because you've gone through this observation process, the next step in the scientific method is to understand. So after observing, understanding, in other words, applying the knowledge to the learned information, is extremely helpful. And we're now starting to talk about the facts of the case, because observing how the decision makers are perceiving those facts is extremely important, because sometimes perceptions don't necessarily overlap. So to gain an overlapping with the mediator, and then even better with the adversary party, is important. So understanding by applying the knowledge learned in the observing stage is the second component of the scientific method. And with all of that information that is accumulated and then assimilated, we're ready to go ahead and formulate a hypothesis for resolution. So what's really important about all of this discussion is that if I were just making declaratory statements as the mediator, that's probably not helpful. Throughout the mediation, it's important to encourage a thinking process that is directed toward embracing the hypothesis. So once you formulate that hypothesis, it means nothing if the decision maker doesn't buy into it. So with the decision maker engaged, the mediator needs to test that hypothesis, and that comes from discussion and how would this work with a revised business deal, for example. We know that you might need this supplier who's adverse to you in this commercial dispute in future matters. What, if anything, can we do to renew that relationship that would sustain itself to the mutual benefit of the adversary parties? So many times I find myself doing that, where the hypothesis is usually starting out with one fundamental credo, which is, hey, like it or not, with all these really smart people involved in putting together this deal, it's a bad deal because it's not working. And people are so upset, they've gone to the courthouse to try to get it fixed because they couldn't get it fixed on their own. They needed they needed lawyers and judges to interface, which is such a privilege for us as lawyers. And that's what the judicial system is designed to do. And clearly mediation is an extension of that. So with the testing of the hypothesis and then deducing from that hypothesis how it will work is the next phase of the scientific method. Once you've gone through that, once isn't enough. It's the next step in the scientific method is to repeat and review.
Repeat that experiment, yeah.
Right. And use so that it doesn't sound like and feel like you're watching a replay of a television show that you've seen. Important to use different metaphors, synonyms, and to make sure that the decision maker is doing the same. If the mediator is the only one talking about the process for resolution, you're not really getting the feedback that the mediator must encourage in order to have an appropriate testing and review of the hypothesis that arises out of the fact gathering. And remember, as a mediator, I would suggest that there's no shame in reviewing the facts in terms of what is really admissible in a court of law. How many times have we all had experiences in talking with lay people and clients where a focus of an outcome of a case is based upon a set of facts that has questionable admissibility in a court of law, or is just flat out irrelevant at the end of the day on proving the elements? So in testing and deducing, there's no reason for the mediator to be shy about serving as an educator who deals in hypotheticals. You know, we all experienced that during law school to the point of annoyance during our first year. But
sometimes tears.
Yeah. but on the other hand, if it's skillfully used by a mediator, that is a great way to engage the decision makers so that the decision makers are actually talking in terms of potential outcome. If you're the one talking about potential outcome, you might be in trouble as a mediator. So important at the end of the day for the decision makers to believe that the resolution of this case was their idea. You know, my great mentor in the trial practice used to tell me that all the time, that in the trial of a case from the presentation of voir dire through summation, if the jurors aren't actually believing it was their idea to come up with this verdict, not your idea, but their idea, you're probably not going to win that case. So the same kind of concept I think applies in mediation, that your jurors, in this case, the decision makers, really have to believe that it was their idea to resolve the case.
All right, so we had observe, understand, formulate our hypothesis, test and deduce, repeat, and then have the clients reach the resolution.
Yeah, that's it. I mean, that's what that's what I try to do. We'll always find ourselves getting sidetracked, but if we can also be disciplined in the mediation process by helping to direct conversation without being the main speaker, then as mediators, I think we're probably really helping.
It probably keeps you on track too, to know what your next steps are.
Right. And of course, and there's probably nothing ideal about an outcome in a mediation except in the court's eyes, that the case is actually concluded, because if we can't encourage and engage all of the decision makers and the lawyers who need to support the mediator at the end of the day, that compromise is fundamental to a mediation that concludes with resolution. We don't have that mindset. Mediators probably aren't going to be successful in their undertaking.
So what are some other tips that you would specifically recommend for commercial mediation? One thing you've said is consider initial separation of the parties.
I really believe that there should not be a substantive exchange at the outset of the mediation. I know so many of my colleagues castigate me for that, for this.
I know, it sounds a little controversial.
It is. But I have no problem with bringing the parties together, but I'd like to know what I'm dealing with first. I mean, if I'm going to find out how the votes are going to get cast, I'd rather do it by segregating the parties and then bringing them together. If you're going to be learning something for the first time and having to respond with everybody in the room as a mediator, it's just my personal opinion that you could put the process into a reverse gear that you're going to have trouble putting back into drive. So I am a big believer in just a hello, brief introductions where everybody can actually observe that all parties are there who should be there. It's also helpful as the mediator, in an initial meeting where there's no substantive exchange, you can read a lot from body language. I feel you can. Sometimes the acrimony is palpable, and sometimes you can find the reverse, where a party or both parties are anxious to try to demonstrate collegiality and cooperation. So I do believe that an initial meeting, but a non-substantive meeting that's quickly terminated, and then the parties go their separate ways. Bringing parties back together again can be extremely helpful. And I've found that I usually need to start by talking individually with lawyers, so that as a mediator in a commercial case, I can get the utmost of candor. I'll get lawyers one-on-one with me, with no one else within earshot, talking through where the lawyers believe the case really is going to land at the end of the day. And of course, we got a range of that in almost every case. It can be everything from a defense verdict to a BAFO win for the plaintiff. You just never know. And any lawyer who says that he or she knows the outcome of the case, and I hear it all the time in my mediations, we're going to definitely win this case. And I say, well, fine, if you're definitely going to win the case,
why here?
You don't need me. But so it's going to be very important to also evoke as much transparency and candor as possible in dealing with the parties. That only comes through eliciting trust, and it's got to be mutual trust too. And as a mediator, you can don't be shy about saying these things. I need to have you tell me exactly what you really believe. I hear your advocacy. This is why you're skilled. This is why you've been hired. But let's just put that to the curb for a moment, and let's talk about ranges of outcomes in a case and why you believe that could happen. So the why word is a very big part of the understanding phase of the scientific method, because I'm going to get insights from the lawyers who have interacted probably already with judges, magistrates, and with adversaries experts and depositions perhaps. That depth of insight, I can't match it as an independent. I really need help there as the mediator to make sure that I've got a grasp of the mindsets and why those mindsets have vested at the stage in the litigation where I'm interacting as the mediator. So Kate, I like to make sure that I'm using open-ended questions when I speak with everyone, and then to direct in a facilitative way. The rhetoricals are very important.
Now, that's interesting you mentioned the facilitative, because there's a couple different styles of mediation we can use: evaluative, transformative, facilitative. And so you say it works well to start with a facilitative style in complex commercial litigation or in mediation?
I would recommend for every mediator that the facilitative style is pursued initially.
And how does that help?
Well, in order to demonstrate that you truly have undertaken your engagement as a neutral, if one comes out of the gates with voiced individual opinions, that you're probably going to lose part of your audience, and for good reason. Mm-hmm. So facilitation really has got to be, I believe, clearly, as we read in all of the academic treatises that I've ever seen about mediation, the facilitative approach should dominate the early part of mediation. And there are occasions when I've never had to get into an evaluative or qualitative assessment and mediation approach. But so many times I've got to say that with complex commercial cases, with the egos, the evolving level of distrust, anger can actually occur in commercial cases because the deal, it gets really personal with the decision makers and those who fostered and who had negotiated, put in place a deal that is probably failing badly or has failed completely by the time that the mediator is on the scene.
All right, so you've engendered some trust and built some relationships with your facilitative style. And then what's next in the mediation?
If the scientific method is working, I can continue down the road with the facilitative style. But I've got to have, I found that I've got to have overlap.
What is a term sheet, and how is that used in commercial mediations?
Great point, because as you know, Kate, what I like to do in my commercial mediations, and it's a prejudice that's evolved over the many commercial cases that I've had the privilege to mediate, is to have each side start to prepare their own term sheets. Here's what's interesting about it is, while each side is doing that, I might be preparing my own. Because if I see that some issues are going to require compromise, that really, I think, falls as a duty on the mediator to help even suggest what might be the right elements of compromise. If we can take a term sheet from party A and term sheet from party B, and we put them together and we've got some overlap, it's surprising how then you've got this focus on just a few items or an item that needs resolution. Usually one of the items is the monetary number. But of course, you might have some steps on how to get there, or some ongoing relationship issues between or among companies that have to be disposed. If you've got a third party company involved, I've also found, I might need to have them involved in the mediation, even though they're not parties to the case. So understanding that by the outset of the mediation and early in the mediation is important, because you might need to adjourn the mediation to make it meaningful. And you can't, and I would recommend mediators, don't be shy about that. Just because you've got a time frame set aside doesn't mean that you've got a statutory period of limitations for doing your job. So I think that what you're talking about by using the term sheets is can be an extremely helpful process for adversary parties. If I can get the parties to start working off the same term sheet, I've got it moving down the road pretty well, I think, toward resolution.
Now, is there a point in time when you might decide to move to a more qualitative mediation, and how would you transition to that?
Well, moving to qualitative,
have you adapted that approach through the years?
I'm finding that particularly in commercial mediation, where with the collision of egos that we referenced at the outset of this podcast, for many decision makers to admit that they've actually compromised can be almost an insurmountable challenge. And if I find that I've gotten there, I'll make a mediator's proposal. And usually what that means, Kate, is I've taken the corresponding parts of the term sheet, and then I'll highlight on my term sheet how to achieve resolution through compromise. Many times, if the mediator can get the parties to have overlapping brackets, for example, on the monetary side, then that starts to present a simple formulaic approach as to how to achieve a midpoint resolution. I know that that's almost become a chant that people find annoying, the discussion of midpoints. But I've got to say that there's no more qualitative approach to how to get resolution than finding a midpoint between monetary numbers and determining whether or not it can work. So in terms of using the term sheet, that's what I try to do, Kate. But that's the last step in the mediation. After trying everything else to achieve resolution, if you believe that you can achieve it through a mediator's proposal, which is the ultimate, I would say, of doing qualitative and evaluative mediation, is the manifestation of that is by presenting the mediator's term sheet, remembering that most of the items on the term sheet have to be items that have been mutually agreed by the parties. That's where I'll go at the end of the mediation. Many times I will ask them to give me a result within a time frame that I think is probably reasonable for whether or not they're going to be able to say yes or no. If they've got the real decision makers there, do you really need more hand wringing? I mean, right. This is all right in the front temporal lobes right now. Let's go ahead and continue the focus. So I encourage that. But on occasion, also, again, just working off of our sense of the situations by the engagement as the mediator, where you do hopefully have the benefit of transparency, honesty coming from both sides as to respective positions. You might want to, as the mediator, give people time to think about it. If I'm sensing that's happening, then I'll set up a reconvene mediation right then, with the sole purpose, hopefully being discussion of whether or not the mediator's proposal is going to work or not.
So for those who are listening who may be completely new to the field of commercial mediation, can you tell us a little bit more about what is a mediator's proposal, and how do you decide if the parties in the case are going to be amenable to that?
Well, first of all, a mediator's proposal is, as I explained to each participating party, a proposed resolution remaining disputed issues. And that proposed resolution is my proposal. And so it's really an interfacing that's borderline intrusive, but it's working for me and my cases. So with care about getting to the point where the mediator's proposal is interjected into the mediation process as an approach to full resolution of the case, has to be done with care. So one of the things that I would say, though, about a mediator's proposal, particularly with commercial cases where decision makers and their egos are infused into the decision-making process, sometimes I feel like the decision makers are relieved that I've offered the mediator's proposal. They don't have to go back to their board and say, this was they can say, this was the mediator's idea. So make me the bad guy, fine, works for me. So,
and they probably respect that progress is getting made and things are getting laid out for them and guiding them along a little.
Right. So with a lot of energy invested into a compressed period of time, considering that a case may have been wending through pretrial and for a period of many months, that we're asking everyone to make a decision within a few hours. It's an undertaking that I think, again, I would reiterate, needs to be done with care if you want to sustain your role as a mediator who is a helpful mediator to bring the case to conclusion.
Can you give an example of a time you've used a mediator's proposal, like what type of case it was and what kind of terms might be included?
Sure. A recent mediation that I did involved a manufacturing company of a product that had incorporated a patented component. So there was a sole source for this component, and that complicated the bargaining positions of the parties once the deal had gone awry. There were some failures in how the component part was working with the product. So to manage this, we and really I just congratulate the decision makers, because they agreed to do this. It was I can't even remember if it was my idea or theirs, but what ended up happening was, and that, by the way, is pretty good. That it was because I think it was collaborative, but there was an independent party that came in to do some engineering analysis and some potential re-engineering specific to how the product would work, how the component would work with the overall product. So we stayed the mediation by agreement, stayed the litigation, got the analysis done, got a fix, came back to, everybody agreed that it was a fix, came back to the mediation, resolved the economic issues. They're still doing business today. That was 2 years ago. And I think it was a happily ever after story. Can't tell you that happens in every mediation, probably doesn't.
That's
But
great,
that was an exemplary result, I think, of thinking outside the box. But it was done with mutual accord, and it was done as a result of the mediation setting, and it was a fantastic result. I think all the parties would now say that too. I wish I could say all my parties with mediations feel the same, but that also underscores the importance for flexibility within the mediation process.
Now, so with the mediator's proposal in that, do you separately deliver to each party the identical proposal, and then they have a time to think about it with their decision makers and then come back together?
Yeah, good question. There's Kate using the hypotheticals that are important in our
Now who's on the hot seat? Professor.
Yeah. So, working off that hypothetical, I would say that's exactly what I do, is that the mediator's proposal is something that I've crafted throughout the mediation day or days. They don't know I'm doing this. The parties don't know. The lawyers don't know. And when I believe that we're on the brink of an impasse, that shouldn't happen because the parties are close enough that just a little bit more reaching will get the job done. And we've all been there as mediators where we've seen that, where if you would just move a little off your position, you can touch each other. You're right there. And so I prepare the proposal in writing. And the reason that I do that is I want to make sure that I'm giving the exact same information to both sides. How many times have we gotten into a verbal presentation and, with intelligent, engaged people, they're going to interrupt you and ask you questions, and then you're off on a tangent. So it's very important to have it in writing, and just handwriting it out is fine, I found. So I will start out in room A with room B, my next stop, and give the mediator's proposal and remind everybody that this is my proposal, that I'll just confess that it's my number. It's not yours. It's not the other side's. This is my monetary number for resolution. These are for the disputed terms. This is my proposal for resolution. Doesn't hurt my feelings if you reject them. And good luck in your litigation. And you'll get my bill tomorrow. But really, it's important that they understand that there's no negotiation with the mediator. It's up or down. Mm-hmm. So then I'll go to room B and do the exact same presentation. So then I say, hey, I'm going to the reception area or wherever you got me staked out, and come and get me. And it's either yes or no. You can't give me any conditions. They still do, but you can't give me any conditions, and come and get me and tell me if it's yes or no. If there are two yeses among the two parties, we've got a deal. We've refashioned your deal. You've got a settlement. If one says no, there's no deal. I don't let the other party know what the outcome is. Now, if one party said yes and the other party said no, then they know what's happened. But I think that's the best way to manage it.
Now,
And
so
if somebody comes to me and asks me, has the other side told you yet what they're going to do? I'm saying,
nope.
I'm not at liberty to give you that answer. I've got to have both the answers, and then I'll let everybody know what the outcome of the mediator's proposal is. Once the mediator's proposal has actually been accepted, which I'm finding is happening in just a very high percentage of my commercial mediation cases, it's over 90%. It's just remarkable. But what I'm doing is I'm just taking the mediator's proposal and putting the heading at the top of the page of mediator's proposal in a bracket and writing over the top of it memorandum of understanding. And then I have everybody sign it. Everybody. The lawyers, the parties, just, to eliminate the revisionist history, make everybody sign it. They're all there. What's the problem?
Yep.
Another thing that'll happen on occasion that I'm just fine with this is if a party does have a problem with the mediator's proposal, that is an element that could be resolved. First, I'll get the lawyers together, just the lawyers for the respective sides with me, have a conversation, and see what, if anything, we could do that the lawyers can support. And I am very insistent that when I speak with lawyers privately, that I remind the lawyers, if you've got a comment that's going to undercut what I'm saying, give me the courtesy of talking to me privately about that, not in front of your client. And I tell them the same thing. Look, on occasion, I'm not going to be thrilled the way you went about your litigation strategy, but I'm not going to do that. I'm not going to talk about that to your in front of your client. And for goodness sake, we all see scenarios where lawyers can be embarrassed in those mediations, missing a defense or failing to file a claim on a timely basis. So the last thing I want to do is become a witness in a case. So it's very important to have these private conversations. And all I can say is when you have conversations like that, Kate, that if handled properly and professionally, it enhances the trust with the mediator. And I would encourage those kinds of conversations at every opportunity. Always speaking with the same group doesn't necessarily produce the level of transparency that we all seek to secure in our mediations.
Now, some people say that mediators should be drafters and not scriveners. But you're saying this has provided a lot of resolutions in your commercial mediation cases.
Right. I got to say, I try not to. If a case is facilitated a conclusion, almost every time I ask the lawyers to sit down and do the term sheet. And the term sheet is really important, particularly in commercial cases, because you're going to have enough detail within the term sheet. If you've got revision of a contract, for example, you may have to have an entire page added just to talk about the language within the revision. It may not be the precise language, but you've got to cover the elements of the revision and have a clear understanding of how the revision is going to be transposed within the revised document. But I really want the lawyers to be, if at all possible, doing the written work that's going to produce the finalized term sheet, with the exception of my occasions when I'm giving the mediator's proposal.
Now, in the slides that I reviewed, you said that you, as a mediator in these cases, you need to identify the basis for resolution for competing non-economic terms and competing economic terms. Do both of those factors come into play a lot in complex commercial mediations?
Right, because when we talk about non-economic terms with businesses, we're not talking about non-economic damages, because rarely in business cases are there non-economic damages. We're talking about behaviors. When referencing behaviors of companies and operatives of companies, that's what I'm focusing on with regard to non-economic terms. How to achieve the various line items within a term sheet. You can often miss the boat and need to remind your parties that, okay, this is your outcome, but how are you going to get there? So if you've got to have revised application of personnel, new implementations, I encourage the parties by saying, well, how are you going to do this? So important again to use the rhetoricals. Heck, they're in a better position too. You haven't been in their plants or their operations. So it's using the rhetoricals and the hypotheticals. The parties are going to get you there because they've got the expertise on how they function.
All right, Mr. Ray, we're coming near the end of the podcast, and here's a little bit that I like to do at the end of all of our podcast here. It's called Two for Me and One for You.
Okay.
And so I have two questions for you, the presenter, and then you'll be able to ask one question to our audience, the listeners, as a pop quiz to see if any of them are paying attention today. So here's the first question for you. What's an interesting mediation-related story you can share with us?
6 months ago, a case involving the Ohio Disability Rights Organization in a lawsuit brought 28 years ago against the Ohio Department of Education achieved resolution after 6 mediation sessions over the course of my 2-year engagement.
Oh my gosh.
That resolution, which was an agreement for the ODR's challenge to the propriety of application of money for children with disabilities within Ohio's public school system, had a terrific result for both sides, we feel. And I think both sides would tell you that publicly. And Judge Mike Watson in federal court just approved the settlement.
Oh, congratulations.
Thank you. But I would just say that the parties demonstrated great patience and great commitment, and both understood fiduciary duties, which is sometimes a rarity, not only within the public sector, within public service agencies, but there's a fiduciary duty that definitely is applied to corporate activity. That outcome was very gratifying because of the demonstration of an awareness of compliance with that fundamental duty of fiduciary law in Ohio.
Sounds really interesting and very far-reaching. It must have been exciting. All right, question 2. Who is an amazing person you know related to the mediation field, and why do you appreciate them?
For me personally, the individual who had the greatest influence on my learning how to negotiate cases was my mentor in the trial practice, who's no longer with us, Michael Colley, who took a chance on me as a lawyer coming out of the prosecutor's office and provided my first opportunity in the private practice. He was president of the Association of Trial Lawyers of America during the year that I first joined him, and that meant that he was gone from the office for a year. As Michael would tell you, I demonstrated my lack of capacity to negotiate cases by trying 15 jury trials to conclusion that year. So we had some nice results, but no money. So when Michael got back after his year of hiatus, he said, "Well, we know that you're okay at trying a lawsuit. We got to teach you how to negotiate." and he just a fantastic negotiator, absolutely the best I've ever seen. So I'm so grateful to Michael Colley on several levels. Unfortunately, I was able to tell him that many times before he passed away.
Oh, that's nice. Okay, now it's time, your chance to give the audience a knowledge check. What's a pop quiz question they should be able to answer after listening to this podcast?
Well, I would just say, what are the elements of the scientific method? Can you remember those off the top of your head? Are you able to regurgitate those elements? And then once you've learned them, can you apply them?
All right. And do you have any closing remarks, Mr. Ray, before we sign off today?
Well, I would just say to anyone involved in the mediation process that really is one of the most important things that we do in the civil justice system. I remember the first time that I heard about mediation, which is in 1981, when the Franklin County Court of Common Pleas started Settlement Week. That it sure seemed to me like people were trying to put me out of my job as a trial lawyer. Little did I know that ultimately I would be on the other side of that evaluative process and would be looking at mediation as the high road in adversarial confrontations where compromise at the end of the day achieves resolution.
Right. Well, thank you so much, Frank Ray, for being with us today to talk to us about commercial mediation, all your tips. Thank you to our audience for listening. And thank you to everyone out there working for justice and resolution in our court systems. Thank you.
Thank you, Kate.